Good morning, Your Honors. Ben Russ of the Nashville Bar. I represent Mr. Jenkins. I would like to reserve 2 minutes of rebuttal time, please.
Two?
Two. Okay. I'm going to break one of my own rules and try to cover more topics than I typically do, so hopefully we'll get through them. The first one that I wanted to address this morning is the equal protection argument that we have raised. I know the court said that they'd read the briefs, but not the record. Ms. Jody Bell, who is an attorney here in Nashville, had represented Mr. Jenkins throughout the majority of the litigation leading up to the trial, and sometime prior to trial, she motioned the trial court asking for second chair counsel to be paid through the administrative office of the court. She was appointed on this case as well. The trial court had refused, and Ms. Bell, literally out of the kindness of her heart, agreed to continue to represent Mr. Jenkins pro bono if the court would then appoint a second lawyer who could be compensated to complete the trial, and that's what happened. I would like to say, based on my reading of the state's response, this issue isn't waived. The state has said essentially, well, there isn't an issue here. Ms. Bell presented a problem that she then resolved herself. She resolved the issue, but the problem remained. She was saying, and I've argued again in the brief, and we do have some testimony in the record which the court can look at from the motion for new trial. Had Mr. Jenkins been arrested and been able to be represented by the Public Defender's Office of the 20th Judicial District, and I don't know the basis for the conflict, that's somewhat in ancient history. I believe Mr. Williams, one of the witnesses, had previously been represented by the public defender, and that was why they couldn't represent Mr. Jenkins. Be that as it may, had he been represented by the public defender, he would have had multiple lawyers on his case all the way through trial. He would have had access to investigative services without having to ask the court for additional resources.
So do you think that equal protection applies in all the other counties in Tennessee where somebody only gets one lawyer in a first-degree murder case?
I think that in Mr. Jenkins' case, in the judicial district where he is,
but this is the state of Tennessee, and the statutes all apply, and equal protection should apply across the state. So wouldn't you suggest then that in all parts of the state where you have a first-degree murder, that there should be two lawyers appointed based on your protection?
I think that would be ideal, yes. However, I understand the court's question.
Under the Constitution, equal protection is what you're saying, and I'm trying to figure out is, when does that apply? I mean, are you saying it only applies in Davidson County?
I'm saying in Mr.
It doesn't make any sense to me. If you have an equal protection, it should apply all across the state, wouldn't you think?
I think that yes. To answer the court's question, I think in a perfect world, absolutely. However, I think that I think that I understand.
The issue is under the equal protection clause, if somebody else gets two lawyers in Davidson County, then you're saying your client should have two, and that should apply all across the state.
I think that it should. I think more, what I'm trying to say is two things. First, to answer the court's question, yes. I think that if that is essentially what the standard of representation is for indigent defendants, that should apply to Shelby County or to, Murray County, Williamson County, any county that you choose. However, I think particularly for Mr. Jenkins, because, and again, this is in the record from from a public defender who has served a long time in the Davidson County Public Defender's Office, that is their practice in the jurisdiction, the judicial district where Mr. Jenkins was charged.
Practice and equal protection under the Constitution are two different things.
Well, again, I think that in order to provide the constitutional protection, the state makes an argument that I essentially am arguing the other way around about an ineffective assistance of counsel argument. I think that makes the representation that's provided to indigent defendants at the bare minimum level. I don't think that's satisfactory. I disagree with that argument on the basis of it or on the premise of it.
Mr. Rush, you're arguing about the public defender's office having lots of lawyers they can throw at this case. So do you think we ought to have a policy in Tennessee or maybe a rule that you can't appoint single practitioners because they're by themselves, they have no one to help them? We ought to have firms representing these defendants?
I think that I think the onus should be on having done this many times myself, but the onus should be on, as it was here, on Ms. Bell, the lead counsel. If she is telling the court, I don't think that I can give Mr. Jenkins or another client the representation that they should get in what is obviously a very serious case, unless I have a second chair counsel, I think the court should take that at face value. If we were here on a car burglary or we were here on a misdemeanor assault, or the trial court was hearing a similar argument, I could see it being skeptical. But I have a hard time thinking that the trial court would think that Mr. Jenkins or someone else who was similarly situated would be disserved by additional counsel.
Well, she got what she wanted. She just didn't get it in the way she wanted it. Isn't that correct?
Well, yes and no. I mean, Your Honor, again, if we had a pool of lawyers who were willing to second chair for free, because essentially that's what happened, she ended up, though primary counsel, taking no compensation after that point. So if you can get, one lawyer plus a person who's willing to do it pro bono, I guess that resolves the issue as far as this particular case, but I don't think it solves the problem, and that's why I say I don't believe this issue is waived, because I think that the solution Ms. Bell came up with doesn't really address the problem. It just addressed the need in that particular instance. She still is making the claim Mr. Jenkins is not being treated like other indigent defendants in Davidson County because he can't have two lawyers who are compensated. I, Ms. Bell, or me, Mr. Russ, if I had willing to do it, have to sit there and help for free. So I would disagree that that is a solution to the problem in the grander sense.
So what do you think let's suppose we found that there was an equal protection. What do you think should be the response from our court? I mean, what should we do?
I think in this instance, I think that a new trial.
But he had two lawyers. Isn't that what he requested?
Again, I can't speak to whether or not, I mean, I would assume or I would hope that anyone who was willing to take on this would be giving their best effort regardless of whether or not they were compensated.
Two lawyers.
Yes.
He ended up with two lawyers.
Yes.
Okay, so what would our resolution be? Other than just say, hey, the court should originally have appointed two lawyers?
Yes, and I think,
what's the effect of that other than us making policy?
well, I think that this is an issue that needs to be addressed.
In your case, what's the effect?
I mean, again, if Ms. Bell, for example, in 2 years prior to trial or however long ahead of time could have had a second chair lawyer the entire time, I think it would have benefited Mr. Jenkins. I can't point the court to saying, this issue was overlooked because of the late arriving counsel, but I do think that this court, could find that this was unfair to Mr. Jenkins, or the trial was unfair to Mr. Jenkins. So to answer the court's question,
Could we also find that it was moot because he had two lawyers at trial?
I mean, the court could find that, but obviously we respectfully disagree with that position. So,
Isn't this, Mr. Russ, more of a post-conviction issue?
no, Your Honor, and again, not in my opinion. I'm not alleging that Ms. Bell was ineffective, if that's the court's question. I think, again, the standard, and this is how the state couches this argument, I don't think the standard should be the bare minimum of adequate counsel that satisfies Strickland. So no, I would say I don't think it's a post-conviction issue. Unless, of course, as far as an ineffective claim, if the court is claiming that there's been a different abridgment of constitutional rights, I mean, perhaps that could be addressed in that vehicle. Ms. Bell raised this, of course, pre-trial, and I felt it was right for this court. Obviously, the court will deal with it as it sees fit. But as far as
I kind of agree with Judge Montgomery. What can we do?
Well, I mean, again, I think the court could determine that the trial was not fair because Mr. Jenkins did not have the same resources. I understand the court factually accurate that he did have then two attorneys through the course of his trial and sentencing. However, I would say that having one of them paid and the other one is not paid is not the same. And so I'd say that could result in...
So you're saying an unpaid lawyer is not competent?
No, Your Honor. And again, I don't think this is a competency issue. I don't think this is an ineffectiveness issue. I simply...
As far as you know, both lawyers were effective?
As far as yes. I mean, I'm not making the claim that they are not, no.
Okay.
So. Moving on to another issue. Again, I'll try to get through these if I can. I think, and the court may or may not have listened to Mr. Jenkins' statement that was entered against him, and that's been the subject of a lot of different argument here, but the particular issue I was going to address quickly if I could, Mr. Jenkins' statement that he made to his girlfriend, Ms. Vargas, which happened on a jail-recorded phone call, within a relatively short time frame after he was questioned for the third time by Detective Holt, who was the lead detective in this case, led to some incriminating statements that he made. And they were generally of the nature that Mr. Welsh, the man who was killed, he believed that he had some animosity towards him. He was armed. Mr. Welsh, Mr. Jenkins was afraid of him, and therefore Mr. Jenkins armed himself. They then had a confrontation which led to a struggle over the weapons, and Mr. Welsh was shot and killed. In that conversation that Mr. Jenkins had with Ms. Vargas, he relayed a basic version of those details. And then he said, essentially, if the caliber of the bullet that's recovered is a .40 caliber bullet, then that must have been the gun I fired, but I don't think it was me. I think it was Mr. Williams, who later became a state's witness, who was also charged in this indictment. That statement that was entered against Mr. Jenkins is sufficient to raise self-defense, but the trial court disagreed. Mr. Jenkins says in that statement, in the instance, and the state talks a little bit about generalized fear is insufficient, and having talked about being afraid of this guy for hours beforehand is not sufficient. That's accurate. Also, the state argues that, well, if he is, stealing the gun because Mr. Jenkins mentions having to disarm him and that he's afraid of Mr. Welsh, and that's why he's, wanting to disarm him. If he had been engaged in unlawful activity, that could have limited his self-defense argument or potentially eliminated his self-defense argument. None of that defeats that the argument that the self-defense was properly raised by the statement alone, by his admissions, I guess, that there was an altercation, that he fired a weapon, and that the weapon was, by forensic evidence, later determined to be the weapon that had fired the fatal shot to Mr. Welsh. However, the trial court refused to read the self-defense instruction just based on that alone. This then caused Mr. Jenkins to testify, and I will fall on my sword or whatever. Mr. Jenkins did a poor job of testifying. Essentially the state argues that, well, he said whatever that was said in his, recorded statement. What difference does it make? Well, first of all, it opens it up to cross-examination about his prior record. Second of all, it opens him up to cross-examination about his repeated untruthfulness with Detective Holt. Third, it opens him up to cross-examination where he just sounded confused and sounded like he didn't really know what was going on. And so what is the prejudice there? Well, if the jury then hears about him having lied to the detective on 3 different occasions about this case, and he seems like he doesn't know what he's talking about, maybe that's exactly why they rejected the self-defense argument. Whereas if they had only heard the statement that he gave over the phone, and then the self-defense instruction was read, then that would have eliminated the need for him to raise it himself through his testimony. So I would say that is error that we would ask the court to consider, that it was unfair to him. On
the question of self-defense, I meant to look at the record before we got here this morning. I think the state argued or mentioned in their brief that an instruction on self-defense was given.
It was given, Your Honor, but only after he had testified to the events at trial. Ms. Bell raised the issue after the state case in chief, wherein this audio recording was played, and saying the admissions that he made to his girlfriend on the phone are sufficient alone to raise the self-defense argument. And then the trial court disagreed. Wanting to pursue that defense, they felt the need for him to raise it in order to get the instruction. And then, of course, he was subject to cross-examination after that.
So are you saying that there should have been a self-defense instruction after the state's witnesses testified, but before the defense put on any witnesses?
Yes, Your Honor, because
I know the rules permit that, but is it not discretionary in every case? I mean, the judge doesn't have to do an instruction. Even if the judge knew at that point in time he was going to give self-defense, in the final instructions, there's no requirement that he do it after.
No, I'm sorry. Maybe I confused the issue. The trial court refused to give the self-defense instruction based on the evidence adduced in the state's case in chief. They said was insufficient not at that time. I'm saying at the final instructions were not going to include self-defense.
But at that point in time, the defense had not rested.
Correct. Yes. I'm sorry, I don't think I understand the question.
I'm not sure I understand your
point. Okay, my point is that had Mr. Jenkins had the opportunity, I don't think he would have testified at all. He, through his lawyer, said, this is, and I'm sure through argument would have said, this is self-defense. You've heard his phone call to Miss Vargas. He's admitting that he was being assaulted, and that's why he shot at the man. And I don't need to put Mr. Jenkins on to raise enough proof for the judge to instruct that.
But
The judge disagreed.
Isn't that the defense's choice? I mean, there could have been other witnesses that might have, that the defense could have put on that would have raised sufficiently self-defense. You didn't have to necessarily put on his client.
I don't know that, in this circumstance, I don't think there was any other witness that
We
could.
don't know that. At the time, the judge said, right now, I'm not going to instruct self-defense.
Yes.
We don't know what the defense is going to have.
Yes, that's true. And again,
Is a judge not permitted to change his mind? I mean,
the judge only changed her mind, Your Honor, because of the additional proof that was put on by the defense.
but at the end, but the defense didn't have to put that on. The judge may have changed her mind later on, right?
Well, after the state's
Okay,
case,
let me ask you this. It's the responsibility of the judge, after all the proof has come on, to instruct the jury, correct?
yes.
And so if the judge says that, after the second witness, well, I'm going to instruct on this, but then changes his or her mind at the end of the trial, has the judge committed error? I don't think so.
Well,
Again, it's up to the judge to make the determination at the end of the trial, after all the witnesses have testified, and whatever witnesses the state puts on, and whatever witnesses the defense chooses to put on. The judge didn't say, I need to hear from your client, did he or she?
she said that I need to hear more proof.
Okay, she
Obviously,
didn't say anything about your client having to testify, correct?
I mean, no, she cannot instruct Mr.
Okay,
Jenkins to
good.
testify.
So then
but
the judge, then after she's heard all the proof, then does the instructions.
that's correct. Mr. Jenkins' attorney asked for guidance from the court as to whether or not the court believed that there had been sufficient proof already raised. Just in the case in chief, the court said no.
Okay.
And based on that, they made other decisions. And that's our argument, is that based on that erroneous decision, Mr. Jenkins was the only person who could supply the
But she
adequate proof.
instructed on self-defense, so how is that erroneous?
Because he didn't need to testify to raise,
Well, he
the
could've-
quantum of
could've made
proof
that
had already
deci-
been
could've made
raised.
See, that was the decision he made. She didn't make that decision for him. She didn't order him to testify.
Our argument is,
Your lawyer, the lawyer in that case made the determination to let the defendant testify.
yes, our argument is that but for the error of the trial court in the first place, he wouldn't have testified.
But she hadn't instructed at that point in time.
No, but she had been asked about the
It may have been
instructions she
error-
would
It may have
give.
been an error for her not to instruct on self-defense at the end of the trial. But was it error for her to say,
Well, Your Honor, that's the catch-22 that he's been put in that we're arguing. If he had elected not to testify at all, and then the court determined at the end of the proof, I still don't think there's enough proof for self-defense, then he's stuck with that ruling. And then I guess we
but
could
then
come
you
up here and
get
argue
to
that it was
appeal? That's
incorrect.
right, and then we may send it back for a new trial because the judge didn't properly instruct.
I understand, Your Honor. I respectfully disagree with the order of events being necessary to do it that way. I'm already well into my rebuttal time. I did not get through what I hoped to get through, but I'll reserve anything that I have left. Thank you.
Thank you, Mr. Buss.
Good morning.
Morning.
May it please the court, counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. I'm going to limit my comments to just simply to mostly rebuttal of what my friend has argued this morning. So I want to start where he did with the equal protection argument. And the state's position is that when Ms. Bell suggested this, she suggested this solution to the equal protection argument, or to the equal protection claim that she had raised, this is something she suggested herself. She suggested that she withdraw and that the trial court, appoint a second attorney that could be paid in order to represent the defendant so that he can have two attorneys. And as the court has pointed out repeatedly, the defendant had two attorneys for the trial. And because Ms. Bell herself suggested this solution, the state's position is this is invited error. And because this is invited error, this is an issue that the court can
What are you
review only
saying,
for
the
plain error.
Maybe I misunderstood. Invited error, what's the error?
Just this equal protection claim that the defendant makes, because now the claim has changed. Essentially, it was I don't have two defense attorneys, and now it's I only have one paid defense attorney. Insofar as that's an error, that was invited by Ms. Bell with the solution that she offered, and so this court can only review that for plain error. And here, I mean, first of all, the defendant has not, I mean, he still hasn't conceded that this should be reviewed for plain error, and he hasn't argued plain error. If the court agrees with the state's position that this can be argued only, or, raised under plain error, then this court should refuse to review this claim at all. And no clear and unequivocal rule of law was breached. I don't know of any Supreme Court case, I don't know of a case in this court where any appellate court has ever concluded that the Nashville Public Defender's policy of assigning 2 attorneys to represent indigent homicide defendants would constitute an equal protection violation that, as you would point out, Judge Montgomery, would affect every county in the state or every judicial district in the state. I've never seen anything like that. And besides that, the defendant can't show that he was prejudiced such that a substantial right was violated. He can't show that the outcome of the trial would have been different if Ms. Bell had been paid. Basically, as I see it, to have an equal protection claim here, this would have to impact the defendant's right to counsel. He obviously had a constitutional right to counsel, and that right was vindicated. And as my friend has conceded, neither attorney was ineffective. Both were very diligent. Both were very effective in their representation. So I just don't see this as anything that has negatively impacted the defendant. In fact, here my friend has conceded that Ms. Bell solved the problem in this case. And if that's true, if the problem has been solved in this case, then there's really no dispute left in this case. And so even if we were to look for an equal protection violation, it would need to be in a case where the problem wasn't solved. And to me, as I listen to this argument, it sounds more like a right that some sort of a right that inheres in defense counsel rather than the defendant. It seems like the complaint is more, well, Ms. Bell didn't get paid, rather than the defendant suffered any kind of harm. The court repeatedly asked, well, what can we do about this? And I don't know. I don't know what the remedy would be in this case. Moving on then to the defendant's statement about, and whether or not that sufficiently raises the issue of self-defense, just a couple of points. First of all, it occurred to me the defendant still argues that the evidence is insufficient. He has an argument here in his brief that the evidence failed to prove that he intended to steal this gun, the evidence wouldn't sustain that argument. So he had other arguments available to him, other defenses that were available to him, and this is simply a strategic error. The defendant wasn't forced to take the stand and testify in order ultimately to be acquitted. He's arguing that the evidence wouldn't sustain the conviction anyway, therefore there would be no need for him to testify with regard to in order to raise the issue of self-defense, because he's saying the evidence wasn't sufficient anyway. That's a strategic choice that counsel made at the time, and I don't see a violation here. That was simply strategy. And second of all, when we read through the defendant's statement to his girlfriend, I'm going to get my brief because I have more of that statement here. He told Ms. Vargas that, first of all, that he'd heard there was a rumor that he had been talking with Mr. Welch's girlfriend. Mr. Welch was unhappy about it, and he said that he had told Mr. Welch that he and the girlfriend had never been intimate, and he said that Mr. Welch said, "Oh, okay." But then he turns and he tells the girlfriend, he said his pride was in the way. He thought Mr. Welch was trying to play him like I won't use the expletive, but like a fool. And so the defendant said he decided to take Mr. Welch's gun. And so Mr. Jenkins, the defendant, arms himself, and he gets a gun from someone else, approaches Mr. Welch and says, don't reach for your gun, homie. At which point, Mr. Jenkins reaches for his gun. So, based in the defendant's statement, this is a confrontation that the defendant started himself. The instant conflict with something that the defendant started himself. And as the court is well aware, self-defense is not available to a defendant who provokes or consents to the danger. So by his own admission, the defendant starts the conversation by trying to steal Mr. Welch's gun while he is armed with someone else's gun. He made no statement to Ms. Vargas, his girlfriend, that might indicate that he abandoned the encounter or clearly communicated his intent to do so, and therefore he wasn't entitled to a self-defense instruction based on his statement to the trial court, and the trial court didn't err. And again, as I've said before, this was still, as the court has pointed out, this is a strategic approach that counsel took to put the defendant on the stand, and there is simply no error here. Those are the points that my friend has made. Obviously, this was a very long brief with many, 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 many issues. If the court has any questions for me about any of the remaining issues, I am happy to address them. But if not, then I'm prepared to cede the remainder of my time.
All right.
All right.
Thank you.
With that, the state would simply ask this court to affirm the defendant's convictions and the defendant's sentence. The state would ask the court to affirm. Thank you.
Thank you. Mr. Russ?
Just briefly, Your Honors, to address a couple of points. Regarding the phone call with Ms. Vargas, I'm sure the court will listen to that or read the transcript of it more closely. My recollection was that what Mr. Lundy said is accurate, but that Mr. Jenkins had also said that when the two encountered each other, that Mr. Welch was handling his firearm. I don't think he had brandished the firearm at that point. So I think it's debatable about who started the encounter. I think that the further on is that both of them had taken out their firearms and were wrestling over them.
But do you agree, though, that a reasonable trier of fact at that point, before hearing any testimony from the defense, could say your client was not entitled to the self-defense instruction at that point without hearing any additional proof?
I understand the court's question. I believe that there's a very minimal amount of proof that needs to be raised in order for the defense to be instructed and proper. So, again, to flip that on its head, the trier of fact could think that that was sufficient evidence that I was approached by a man who was handling a weapon. I told him, don't do that. I started to pull out my gun. He started to pull out his. Then we wrestled, and he was shot. So I would disagree with that point. Secondly, is to just circle back very briefly to the issue of the second lawyer. How could the trial court have kept, the only thing the trial court did in response to this was allow Ms. Bell to withdraw and appoint Mr. Castle. If that had been the other way around, the court could have refused the motion to withdraw, required Ms. Bell to stay on. She would have continued to be compensated, and if Mr. Castle came on at all, he could have done so pro bono. I've never heard of a court denying a competent lawyer to sit second chair for free. So
how could we formulate at this level, even the Supreme Court could, some type of rule or procedure that says Davidson County, under equal protection, has a right to two defense attorneys? Okay, wait.
Sorry.
What about every other county in the state? How can that be equal protection if you have two in Davidson and you don't have two in Williamson or any other county?
What this court, I think, could do, and I thought about it a little bit over there since you asked the question, I believe that the trial court could have granted this if the trial court chose to, had the authority to do so. And therefore, that puts it back onto the individual trial court and the individual circumstance to say that it was warranted or not. And again, I think there are plenty of examples where I don't think a paid second chair lawyer is the best use of resources. I agree. However, a first-degree murder trial is probably the most appropriate time. So I think that Judge Smith could have said, I agree with you, Ms. Bell. I think in this circumstance, Mr. Jenkins is entitled to a second lawyer. That's paid. And the judge did not do that. So as far as a rule, I think what the court here could do is find that that was an erroneous ruling by the trial court, that Mr. Jenkins was not being entitled to what he would have gotten had he been represented by the public defender, in this case, by that judge. And I hope that answers the question. So. Thank you.
Thank you, Mr. Russ. Thank counsel. Good briefs. We'll take this case under advisement. All right, call the next case, please. Thank you.
State of Tennessee versus Muhammad